hello everyone. I am Esha, your host this morning, and I would like to extend a very warm welcome to all of you from all of us here at Areness, a consulting and advisory firm with over a decade of experience servicing corporate clients. Over the years, we have consistently delivered top-notch business advisory services and practical solutions backed by in-depth research to clients worldwide. Our team House experts takes great pride in offering unparalleled and diverse solutions to our valued clients spread across varied domains like fintech, banking, technology, cosmetics, F&B, government organizations, and so on. Our core strength is our expertise in practice areas like intellectual property rights, cyber law, insolvency and bankruptcy, BFSI, corporate governance, general corporate, public policy and dispute resolutions, and so on. So here we are today and presenting you the second of our series from our webinar series that's been ongoing called statutesphere. And this is in association with ARM Worldwide and Girma Pro. And today's session revolves around a very interesting topic, that is securing a brand's legacy and identity protection insights. It's my pleasure to introduce to you all Ms. Ishita Mehrotra as our speaker for today. She holds a BCom LLB honors degree with specialization in intellectual property rights from Amity University, Noida. She is a dynamic legal professional known for her exceptional commitment to safeguarding and enhancing her clients' intellectual property assets. Her career has been marked by the adept handling of IPR matters spanning prosecution, opposition, and enforcement. Ms. Ishita is highly regarded for her ability to provide clients with sharp and effective services, offering comprehensive advisory on brand protection and management. She excels in devising strategic plans for her clients to expand their businesses through the judicious use of utilization of their valuable IP assets. And with her career trajectory that includes diversified roles with top-notch law firms, Ishita has honed her skills at IP portfolio management, HR policy formulation, due diligence reporting, dispute resolution, agreement analysis, and her diverse clientele spans over industries such as education, technology, real estate, FMCG, cosmetics, fashion, tobacco, media, electronics, pharmaceuticals, F&B, and finance, of course. And for any questions during the presentation, we request you all to type them into the chat box. And for all of those viewing on LinkedIn, they may send their queries in using the comment section. And we'll ensure to cover as many questions as possible by the end of the session. And now handing over the stage to Ms. Ishita. Please take it on.
Thank you, Esha, for your kind words. All right, so today's topic is securing your brand's legacy, identity protection insights. And the agenda for today is that we would be specifically discussing about IP and how it is present in every sector of our lives. We will be unpacking varied dimensions of IP. We will be discussing about how your brand and trademark are different and how, in what sense they may be similar. We will be discussing further about how you must go about securing your brand's legacy, considering that that is the most important and crucial thing to your brand. We would be maximizing the value of your trademark. We'll understand how exactly you can do that. And finally, we'll conclude with global protection of your trademark, because that is as crucial as national protection. So as we discuss about IP and navigating its omnipresence, we must know that IP is all around us. From the time that you wake up to the time you hit the bed, you are actually surrounded by IP, and it has found a way to integrate itself into each and every sector of our lives. Now, I'm sitting in this boardroom and I can spot a chair which must have been created by somebody after applying their mind to it. So in case they, created a technology to ensure that whoever sits on that chair sits comfortably, so they would have obtained a patent over it. Now, if that chair is marketed under some name, then it would have obtained trademark registration over that, the name per se. If that chair comes with a label, a set of instructions which are very unique to your chair, then it could be protected as a copyright. Now, if that chair finds its origin somewhere, let's say from a locality, let's say if this chair originates out of Karnataka, then that would be a GI. This was a hypothetical example, by the way. Then if that chair has an aesthetic appeal, that showcases the design. So as I am saying this, I also want to highlight here that even one product that is a creation of somebody's mind has immense IP that vests in it. Different kinds of IP that actually vests in it. So IP regime basically rewards you for the creations of your mind, and everything man-made has been made after application of mind, and therefore IP vests in it. Now, when we talk about unpacking the varied dimensions of IP, people generally are only aware, most of the people are generally aware that intellectual property only consists of copyright, patent, trademark, invention. However, it is actually much more than that. We have clients who would come to us and say, "Iska patent kara do," but turns out that the thing that they are seeking patent for is not a patentable invention. Rather, they wanted to get their name trademarked, their brand name trademarked. So there is immense confusion within the minds of people with regard to the different kinds of IP and the different kinds of rights that entail through it. So I'm going to quickly run through it. We have trademarks, which are your brand names, your signs, slogans, colors. We have copyright, which is musical, artistic, literary work. We have designs, which basically protect the overall aesthetic appeal of a product. We have patents, which are novel inventions. We have GI. GI basically lets you know that where this product is geographically located. For example, Kolhapuri chappals, Rasgulla, Darjeeling tea as well. Secrets which are very which doesn't have a codified law per se, but trade secrets are protected by confidentiality agreements. Here I would want to highlight that Coca-Cola's formula has not been protected as a patent, and they have actually protected it through airtight agreements because they want to safeguard it as a trade secret. We have plant varieties wherein if a farmer creates a very different kind of a new kind of a plant variety, then that is protected under plant varieties. And we also have a very niche and a less popular area of IP, which is semi-integrators and circuits, wherein if you have created a unique form of a motherboard also, then that is also protected as your IP. Now in India, we only have two as of date. However, we are witnessing significant progress in this area too. Moving on, let's discuss about how do you bridge your brand and your trademark. So there's a very famous Jeff Bezos that your brand is what people say about you when you're not in the room. So what people do is that they end up interchangeably using the terms brand and trademark. However, they are different to an extent. It is not wrong to use those terms interchangeably, but brand is actually a much larger concept than your trademark. And the journey from becoming a trademark to becoming a brand is actually very arduous, and immense research, immense resources are expended into creation of the same. Now, brand is a very wide term which encompasses the conception of the brand, the business practices that you take under it, the quality of your products, the ethics that you employ, the layout, the colors, the logos, the trade dress. So it's a very far wider concept, and your trademark is a sign that would indicate that the products originating from here, this is the brand, this is the significance, this is the brand, this is the name, and that is your trademark. So while it is not wrong to use those terms interchangeably, brand is a much larger concept, and to create a brand, immense resources are employed, immense research is undertaken, immense I should say strategies are employed to create a brand out of a trademark. Very simple to go and get your trademark registered, but it is extremely laborious to create a brand out of it. Now, for following up on this, I would want to give an example of Starbucks. So as soon as I look at just this green logo, I will be thinking about Starbucks. Everything that this brand undertakes, be it their straws, be it their store layout, they have capitalized greatly on this green color, and they have ensured, their marketing teams, their IP teams have ensured to include the element of green, which is their specific color, into everything that they produce. Be it their cups, you will see branding on that. Be it their straws, you will see a green straw. Something as minor as a straw is also branded by the Starbucks screen. Then if you look at their coffee, they have small logos that are placed on it. If you look at their napkin, they brand their napkin with their trademark. So that is the power of good branding, that every product that originates from Starbucks, people would know that this is originating from Starbucks because of the brand practices that are employed by them, because of the strategies employed by them. And why has Starbucks become such a global success? It is because of the fact that they have focused greatly on brand building. They have focused on providing protection. So they are very fierce about providing protection, but they also understand the value of enforcement. So people tend to think that, okay, today I'll go and get my trademark protected, and then that is it. Now I have registration, I can use it. Of course, you can use it, but you must also enforce your rights. By enforcement, I mean that you must stop other parties from using something similar in the market. We will be discussing why you should undertake this practice later in this presentation. Further, Starbucks has emphasized strongly on brand values, consumer centricity, and owing to all this, Starbucks has achieved the kind of momentum it has in the market. Now, also another example that comes to mind when I talk about Starbucks and its enforcement practices is that recently somebody had introduced a brand by the name Sardar Baksh Coffee, riding upon Starbucks reputation, and people could to an extent associate it with Starbucks coffee. So Starbucks did not let that go. They went behind them. They fought the case fiercely, and they ensured that material changes are being made to that brand name so that nobody is able to even create some sense of association between the two. Imagine the amount of investment that this brand undertakes into its IP. There are about 6,000 plus trademarks that they have protected globally, and around 551 trademarks in India. So that is the kind of investment that you make into recognizing, analyzing each aspect of your brand before you even proceed to protect it. So what exactly is a trademark? Trademarks are signs that represent your brand. People generally limit it traditionally to names and logos, but it is actually much more than that. It keeps developing as you continue with your brand throughout the market. So let's say, look at this blue box per se, the kind of significance that Tiffany's blue box has created in the market is such that even when I'm looking at Instagram videos and I see somebody opening a blue box, I am instantly reminded of Tiffany and Co. They have also sought registration for this blue color in various jurisdictions. So that has been undertaken and done because of the fact that they have created significance. They have used their trademark in a manner which is appropriate for popularizing your brand. Now, as I was saying, the trademarks are signs that represent your brand. So it is not just the name, it is not just the logo, it could be your signature, like I have represented here. This is Sachin Tendulkar's signature, which is a registered trademark in India. We have buildings. So Taj Mahal Palace was recently granted registration over the building. We have layouts, like Mary Coher had applied recently for the store layout for its registration. We have jingles and songs that are exclusively associated to a brand. For example, Nescafe's jingle or Brew's jingle. So once you even listen to those small jingles that may not even mention the name of the brand as such, you would be reminded that this originates from this brand. There might be certain slogans that are very famous and that are associated specifically to a particular brand. There are signatures, buildings, layouts, jingles, songs, colors, slogans. There are so many things that can be encompassed within your trademark. So everything that represents your brand, its value is your trademark. So all activities that you would be undertaking under your trademark, under your brand, would be represented through your trademark. So if today I go to a brand and I'm dissatisfied with their services, I am not going to tell people that this outlet place, that this place did not provide me good services. Instead, I will say that I will use the brand name when I'm disparaging the other brand because I am not satisfied with them. Or if I get good services at a place and I want to recommend the same to my friends, so that would also happen once I take the name of that place. So that is how immensely important your trademark is to your brand. Your identity lies in your trademark. It lies in protecting your trademark. In power of good branding, I have explained already that how Starbucks has done that, how Tiffany has done that, even Milka chocolate bars, they have protected their purple color in various jurisdictions because people recognize that Milka chocolate bar through that purple color. So, uh, for that matter of fact, even if you look at an interlocked C, you would be reminded of Chanel. So that is the impact that your trademark has, that there is an instant sense of recognition, instant sense of association between people, between their minds, as soon as they look at your logo or anything that is associated or could be traced back to the source of business. Now, recently, I also read a case study which was about an Indian entrepreneur, Mr. S.K. Maltani, who introduced jet mosquito repellents under the name of Jet. So it was a patentable invention. When they had launched it, they had conducted immense research into creating something like that in India. At that time, India did not have much of these kinds of products. So he invested around 65,000 US dollars into that brand. And that irrespective of how much I would want to protect my invention, people are not going to buy it until and unless they are aware that this brand is famous, this brand holds some value. I may not go out and buy a repellent from XYZ brand, I may go and buy it from HIT because of the kind of significance that it has created in the market. So at that time itself, long back in the 90s, Mr. Maltani understood that value, that everything which originates from a well-known trademark can be easily bought out by people. People will spend extra to get that product off the shelves. So he invested his funds majorly in protection of his trademark. And can you imagine that at the time in around 1995, when Godrej wanted to enter into this market, they bought out this brand at 65 lakh US dollars because of the kind of significance that this brand had created. So it was a win-win situation for both brands because Mr. Maltani had realized that this brand will not reach farther more potential than it has already. So he sold off his rights. And Godrej bought out a well-established brand. So they did not have to invest too much into popularization. They just had to probably invest into creation of more sub-products under it. The power of your brand, that is the value of your brand, and if you are harnessing it properly, then I'm sure that you would be able to commercialize it to an extent which is unparalleled. Many startups, many entities do not recognize the value of their trademark until and unless they have created that kind of significance in the market. So it is essential, as I just highlighted, with how other brands are doing it and how we should also be following in the steps, because entities are understanding the importance of safeguarding your trademark, because ultimately everything boils down to the fact that this originates from here. So this is my trademark. Everything originates under this brand. Now let's talk about how should you be securing your brand's legacy and what are the importance and repercussions of not protecting or enforcing your rights. So before we even set up understanding how you should be securing your brand's legacy, I would want to point out that there are certain steps that you can take before you even enter into a business. So before you enter into a business, before your business enters into the market, it is natural that you have an idea in your mind and you would want to capitalize on that idea before it even enters the market, right? So you ideate and then you analyze the IP that you have already created before it has been launched into the market. So analysis is essential because one, it would help you understand that what if I'm infringing on an idea that already exists in the market? What if the kind of IP that I have can be utilized in a much better way than I'm utilizing right now? Or maybe this idea may not appeal to people as such, and how do I allocate my research in a manner that people end up understanding and accepting my brand in the market? So you have to analyze the IP that already exists before you launch your business, devise a trademark. When you set a strategy, you have to devise a trademark by carrying out a clearance search. You have to ensure that your trademark is not infringing upon somebody's pre-existing trademark. So India is a first to use jurisdiction. So in case somebody is already using a trademark which is similar to your brand name, then it is natural that you may not be able to effectively use that trademark in the market. Of course, there are exceptions to this. There are ways to go around this, but when you are devising your trademark, you must ensure that maybe your teams sit down and conduct a clearance search before you introduce that trademark into the market. So it is free from encumbrances, free from any kind of litigation that it may attract right after it launches itself. Then you must also, right from the start, identify your target market and audience. So by target market, I mean that you need to understand the jurisdictions you are going to target within your country and whether you want to go global. Let's say in the next 5 years, you would want to go global. You must identify that market as well so that you can start with getting and obtaining protection in those jurisdictions. Understand the competition. When I say understand the competition, it means that you have to understand the kind of IP they are using. You must also understand that how they are exactly using their IP to popularize their brands, what kind of branding they are undertaking to make sure that their product is appealing to the public, and whether there is any IP that they are using and you may have unconsciously used. Though what happens sometimes is that you would not come into the market with the intent of infringing upon someone's right. You may think that you have adopted and created something independently, and it is very natural. This happens quite a lot, that you would come up with something and you would think this is my original idea, this is mine, and I have not even looked at any form of research for this. So this is something that is unique to me. You would come with that intent in the market, and it is very, very common. However, what happens is that there are chances that somebody else may have thought of it before you. So you need to analyze the competitors that exist in your particular industry who are dealing in similar products or services, so that you are able to be completely diligent that no other party in the market is using something similar, and so you can bring something new into the market, because once you bring something new which appeals to the consumers, it becomes a hit like this, of course, if you brand and strategize accordingly. Then you also need to set policies in place. Now when I say policies, before you enter the market, your policies regarding how you would want to protect, safeguard your brand must be set properly. You need to understand that policies for protection of your IP don't just include that these are my trademarks that I want to protect. It also includes the kind of agreements that you would want to enter into with your team members. Now, it is natural that your team members are not going to take away your confidential information or your intellectual property, but specifically demarcating that the IP that you are licensing other people to use belongs specifically to you. Now, what this problem is very common and pertinent when you are using other OEMs to manufacture your products. They may either be based in your nationality or they may be based in other jurisdictions. Most commonly, this happens when your OEM is based out in China. So it is a first to file country and not a first to use country. And let's say today you have asked an OEM to manufacture a product which originates from you. You have told them that this is my brand name and this is the reason why I'm asking you to manufacture this. They may end up replicating your products or even using the same products and introduce them into their market, obtain registration of your trademark, and you might be left with just frustration in this part, because what happens is you will have to contest a lot to get your rights in your trademark itself. So you have to be very particular, you have to be very strong agreement wise as well to demarcate where the ownership of your IP lies. You have to be very smart, you have to strategize accordingly, so that in case you are hiring third party vendors for performing any kind of services for you, you have to ensure that they are also clear that the IP in that vests in you, nobody else. If you are paying for that, then it is but natural that you would want that IP that you have created stays with you and it is not used by somebody else. Now, you must also allocate a budget for protection and enforcement of your IP. So, setting a budget, of course, with IP, you cannot have a very clear cut budget from the start because you may never know the kind of IP that you may develop as you go along in the business. But from the start, try to keep some budget specifically allocated to your IP so that you are able to protect and enforce effectively, and there is no paucity of funds at the time that such a need arises. And then, of course, protect your trademark. Some entities choose to do that even before they enter into the market, and they create a very wide and large trademark portfolio to ensure they even get protection over parts of their trademarks so that any third party is not capitalizing upon the IP that you have created after immense labor. Now, after you have launched your product, your business, there are certain other things that you need to keep in mind. So, as your brand would develop, it is but natural that different elements of your brand would develop with them. Let's say at the start you just started out with a name, and now your brand has a color that is associated to it. Now your brand has slogans. Your marketing team has also created some taglines. Your marketing team may have created some jingles. So, many things that would be associated specifically to your brand per se. So, you are supposed to protect each and every element of your brand. There is a very gross mistake that many startups, many entities actually, they make is that they would take a trademark, obtain a trademark only on the house brand name. Let's say if my brand name is XYZ and I would want to protect that, then I would only obtain registration on that. But if I have launched, let's say, 10 products with wherein I am using the term XYZ in association with the brand, products names, then there I should be taking registration over each and every product that I am launching into the market. Because as per the trademark law, section 17 of the Trademarks Act 1999, it clearly states that you cannot use your trademark in parts. If you want to get registration, you will get registration over the entire trademark. So you would be required to use it also in accordance with that. So why not protect each and every element of your brand as they are developing? And a very good example of this would be Louis Vuitton. Louis Vuitton has a very wide trademark portfolio wherein they protect each and every element of their brand, be it Louis Vuitton, be it LV, be it their monogram, be it their designs, the monogram, even the label of that monogram they have protected under trademarks because they recognize that they analyze their IP very clearly and they recognize that we will be using different IP on different bags that we produce. So they are ensuring that no other person should be able to probably copy something like this, and they take strict action against entities after, of course, weighing their options. They take strict actions to ensure that no other person is even able to infringe upon an element of their trademark. So that is the amount of diligence that is expected from a business if they want to become very relevant in the market, if they want to become extremely authentic in the market. You must go for that. Then you must also train your teams on effective usage of your trademarks. By effective usage, I mean, now picture this, that you have launched your brand into the market. At that time, there was a strategy that was set, but let's say a couple of months later, or maybe a few years later, you change the entire strategy which pertains to your brand. So at this point, the new marketing team that may have come on board that affected this strategy might not be aware that why previous branding decisions were taken. So steps here would be to first create a log of all branding decisions that you are taking and why such decisions are being taken. And let's say they made a minor change to the trademark right at the start because they figured out that something similar exists in the market. However, the new team that would come on board might not be aware that this is the reason why this kind of a change was effected, and they may make that change and they may revert to that original trademark that was infringing upon someone's rights, and they may start using it. So training and creating a log is extremely essential so that everybody, whoever may join your organization, is aware that your trademark, why, what is the journey of your trademark, how you are branding your products, and uh, why a particular decision pertaining to your brand was taken. And when I say train your teams on effective usage, I also mean that you have to educate them that how your trademark should appear on a particular product or a service that you are providing. Because you might have a set of colors that are typical to your brand. As I just mentioned, the Tiffany blue or maybe Starbucks green. So teams have to be trained to ensure that they don't use a shade which is even zero point 0.5 shades dissimilar to your shade. They have to use the shade which is exactly the same, so that the marks used is being accounted for, that kind of significance is being created in the market. So you have to ensure that your teams are also in loop, they are trained with regard to effective usage of your trademark, so that you are able to create that kind of significance in the market. As I said, that when I'm looking at an interlocked C, I am instantly thinking about Chanel. So that is the kind of significance that you would want to establish in a market. Then protection, as I already stated, protection alone is not useful. You need to enforce your rights. You cannot just take protection and leave it. Okay, I have protection over 10 trademarks and now I can use them freely wherever I want, and that's it. Your responsibility doesn't end there. You also have a responsibility towards the consumers that you are serving. Because what happens is, in case somebody launches counterfeit products into the market, and they, especially talking about industries like pharmaceuticals, cosmetics, F&B, so there may be a chance that the counterfeit products don't meet the standards that are safe for consumption or for being applied on your skin, and they may end up causing a corrosive effect on somebody's health. So at that time, when that counterfeit product enters into a market, at that time, that person, whoever would have been at the receiving end of it, the consumer, they would not be aware that this product does not originate from you. They would think that this product I bought because I believe in the value of and the products and quality of this XYZ brand. However, that you were not the person who was responsible for introducing such products into the market. Now it has impacted someone adversely, and with the power of social media, that person may go on the internet. They may write denigrating things about your brand, and how their brand was their health was severely impacted because they consumed some of your products, and within a matter of minutes, boycott XYZ brand will start trending. You will have to spend a lot into just ensuring that people become aware, probably at a later stage, that that product never originated from you. But by that time, your brand's value is already degraded. By that time, your brand's repute is already diluted. So to avoid that, to ensure that your brand's reputation is maintained, enforcement is very critical. Specifically, it is not just critical in these industries, it is critical all over, to maintain that kind of authenticity and trust in the brand as well. Then commercialization of your trademark. So IP regime does not just protect and enforce your rights. Instead, it also helps you commercialize. It helps you earn through your mental creations as well. You are earning through selling your products either way. But how should I use my trade when we discuss about maximizing the value of your trademark? And I would also take a valuation therein. And I would suggest that entities, after launching a business, must conduct regular IP audits. IP audits are extremely essential for a business, no matter at what stage you are at. Try to conduct IP audits as much as possible, because it helps you stay in loop with the kind of IP that vests in your business per se. So when we talk about IP audits, what exactly are the activities that you have to undertake through this? Would be that you analyze your IP. You identify, when I say analyze, you first sit and identify your existing IP. You take out your inventory, you study your inventory, and you try to understand what IP already exists, what IP you have, but whether that IP is actually owned by you or not. Then the potential IP, the IP that might be there through ideation that may have been created, but it has not yet come into existence. So you analyze all aspects of your business here. You analyze the IP that you have created, and you analyze the IP that has the potential of coming into existence. Then you also, while analyzing, you check whether you actually own that IP, whether protection has been provided to those IP or not, whether ownership vests in you or not. Then you also you basically would conduct complete end-to-end research and monitoring pertaining to your own IP. Then you would identify the policies and strategies that you have adopted for protection of IP. Here, as I had highlighted, that you are supposed to create certain policies in place to identify ownership of your IP, to identify how you should be protecting your IP, how you should be developing upon your IP. So potential strategies and policies have to be adopted, and you have to identify them. You have to understand the scope of such policies and strategies, and you have to ensure that those strategies are effective and in line with the current landscape. Then you ascertain the IP that is being used by your entity. Here you are conducting due diligence to check whether you are infringing upon somebody else's IP by putting that into use under your entity. You also understand the commercial impact of the IP on your business. So there may be certain IP that might exist in your brand and that requires extra funding to garner more commercial benefits for your company, and there may be certain IP that would actually be unnecessarily draining your finances, and you can upon whether you would want to assign and sell it off or donate such IP. So at the time of analysis, you also understand the impact that the existing IP is having on your business. You will realize that there are a lot of IP that have a potential of becoming much far bigger than they already are, and they may be able to generate significant revenue for your business, and that can be undertaken by proper analysis of your IP. And by actually through this, you also devise strategies, of course, that where would I want to allocate my funds, where would I want to not allocate my funds any longer once I realize the potential of IP that exists. And then you evaluate your IP through effective valuation thereof. So commercially exploiting your IP is one thing, but you can only commercially exploit it after you have actually evaluated your IP. So moving on to maximizing the value of your trademark, you can actually earn through your trademark. And how can you do that? One method is to assign your trademark to somebody else. By assign, that is like a one-time value that you would generate out of your trademark. The other is licensing. The most common form of licensing would be franchising, wherein people just license, they execute non-exclusive licensing agreements. They may generate far more income through that by probably giving one person the license to run a restaurant, the other person to create merchandise, the other person to probably manufacture sauces under your brand name. So licensing generates far more streams of income for your business, because you are giving the right to a lot of different brands for using your trademark and paying you some royalty in return of it. Trademark can also help you in fundraising. Based on the value of your trademark, people associate a sense of trust with your trademark, and it helps you in raising funds as well. Further, if you have the potential of even contributing to the growth of your economy, of your country's economy, by cross-border sharing of your trademark. So you can actually internationally go the licensing way. You may give rights to somebody else based in another jurisdiction, and you can earn through that as well. And you will be bringing funds into your own country by cross-border IP sharing. But all of this is only possible after you have thoroughly evaluated your IP, you have valued your IP, you have understood that this is the value of my trademark, and after that you go the commercialization way. Otherwise it may not be as effective, because somebody who may come to you for assignment, for sale of rights, they may come with the agenda that they set a price for you. But if you have evaluated your IP during IP audit itself, you would be aware that this is the value of my IP and I am not going to accept any money which is lesser than this. So you are actually making a very business informed decision here, because you are clear with the value of your IP and you should not settle for anything less. So why protect your trademark? As I have highlighted previously also, that protection and enforcement go hand in hand. It is necessary, one, to maintain authenticity, to ensure that people are able to trust your brand, they are able to reliably rely on your brand. Because what happens is, when a company allows other counterfeit products to exist in the market, that trust diminishes and people may not buy your product with that much enthusiasm. They would be always skeptical before buying your product, because they would think that this product, there are a lot of counterfeits that are already available in the market, so I need to first analyze whether this is authentic or not. But an entity that ensures to take enforcement actions swiftly, those entities ensure to safeguard their brand's image in the public's eyes. They are able to attract potential investors as well, partners, collaborations, and whatnot. So protecting your trademark's value is excessively important, because not just for brand maintenance, but because of the responsibility as well that you owe to the consumers. Now, we would be concluding with global protection of your trademark and why exactly that is necessary. So, before launching your brand, as I had said previously, you must analyze your market to understand the market that actually is most profitable to you. And accordingly, you must start by seeking trademark protections there. And why is this suggested? Those who do not exist in that market at that particular moment is to ensure that, see, what happens is, many entities, they have the business of first understanding another country's market. They would analyze that, okay, these brands are doing much well in their particular regions and they may end up expanding globally. So because there is no such clear provisions pertaining to trademark squatters, these squatters seek registrations in other jurisdictions to delay your entry into that market. So seeking protection before something like this happens is actually a less costly affair as compared to when you would have to ward off a trademark squatter, because there the cost of litigation would arise and it would be absolutely extremely high for you. Now imagine the impact of a trademark squatter. Burger King they had to change their name to Hungry Jacks in Australia, because somebody in Australia was already using the term Burger King and they had established a very huge business there. And imagine in India, Sony's PS5 could not be launched timely because somebody has sought registration here. So to get your trademark back from some entity like this is already very a tedious and tasking affair. So it is much more better that you seek protection in the relevant jurisdiction before a need for this arises. And before I conclude, I would also want to add that also, when you are going to protect your IP in another jurisdiction, ensure that your trademark's name is not derogatory, because Pajero actually had to change their name in China, in Spain, because there the term Pajero was considered as offensive. So you have to actually analyze and understand uh, another market's landscape before you reproduce your trademark there. Also, this is being said keeping in mind that you garner immense reputation in another country that flows to another country. So changing your trademark at that stage is actually not recommended, because at that stage, if you have to inevitably change your trademark, you would have to restart your business. You would have to restart the process of gaining that kind of goodwill in the market. So why to go through all that hassle, and why not protect in advance? Right? And before I end, I would just want to conclude with conduct IP audits as much as possible, analyze the products that exist in your markets, in your brand, so that you are able to accord effective protection and enforce your rights also that effectively. So I think we can start with the questions. We are short on time already.
Thank you, Ms. Ishita. That was brilliant and absolutely insightful. And we have a few via LinkedIn as well as the WebEx chat. And in case you come any questions, I would encourage you to please place them. And let me take up the first question that was posted by Shaurya. He says, could you please explain the significance of conducting a comprehensive trademark search before the registration?
Yes, absolutely. So before you enter into the market, you actually have to choose different databases to conduct a search to know that if somebody else is already using your trademark. So as I had said, this is very common that I might create a trademark which I may feel is very original, something that I have created and I have never heard of it, but there may be a chance that somebody had actually already thought of it and they are using it in trade. So once you conduct a search in advance, before you even set your business into the market, you bring your trademark into the market, this avoids potential litigation and disputes over your trademark, because you would be clear right from the start that this trademark, this brand, this trademark belongs to you and nobody else has been using it and you have priority. And you would be able to establish the fact that this is mine and nobody can infringe on that. This is the same kind of strategy that a prior mark, the one that we may find while we are conducting search, holds. So conducting prior search would help you actually understand if somebody else is in the market, and you can take decisions accordingly to alter your brand so that you don't have to do that at a later stage once your goodwill is also established, because at that stage altering would be very denigrating to your business. It may even invite losses, and the kind of goodwill that you would have created may also suffer because you would have to change the name.
Just so that you have a minute to think about a little for the next question. The question is, how can one involve their team members in maintaining and safeguarding their brand identity? And Ms. Palak has asked this question via WebEx.
I guess that issue has been handled, so I'll just take this. You can actually involve your team in protection and safeguarding the reputation of your brand by, let's say, you have to first educate the team about what is your trademark. You have to tell them that this is a list of. Am I audible?
Yes, yes, you are, ma'am.
Yeah. So you have to let your team know. You have to actually, you can provide them with a marketing package by explaining to them that these are my trademarks, these are my colors, these are my logos, these are my slogans. These are the things, these are the package of marketing items that we use, and you educate them on using them correctly. So once they use it correctly, you would already be invested in popularizing your brand. And you also have to educate them about not using somebody else's marketing material. Now what happens is someone may create some marketing pitch through ChatGPT, but that was not tailored as per your brand, and probably they did not know how to use ChatGPT well. So that pitch may be used by let's say 3 4 other people as well, and there might be potential conflict between such brands because you relied on AI without actually understanding how to use it. So you have to also educate your employees about effective usage of AI tools in case they are involved in doing that, and you have to make them understand the value of not copying somebody else's marketing material. So I would suggest that training your teams with regard to effective usage, with giving them your brand kit, making them understand that these colors are associated to you, these logos are associated to you, and you have to also make them understand that what are the dangers of copying somebody else's material and how it may be fatal to the brand. You have to employ very strict policies in place to ensure that your team does not infringe upon somebody else's rights also.
Perfect. I think Ms. Palak, your question is answered. Now, going on to a question on LinkedIn. It says, please enlighten us regarding the exceptions to introduce trademark that are similar to already existing brands. What do we know how we could circumvent or use relevant provisions in our advantage?
See, so if basically as per the law, in case there are marks that are identical to each other and they exist in the
Mm-hmm.
market, they can coexist if they are being used in diverse industries and there is no overlap between those industries. So the Nandini Deluxe case, basically it specifically highlights the point. The Supreme Court also affirmed this, that one mark actually cannot even claim monopoly over one classification of goods and services. So agar
Okay.
you are dealing, let's say, with cosmetics, but it also deals with laundry and detergents. So these two industries are very separate in actual, because somebody who may be involved in providing you with detergents, that entity might not be dealing in cosmetics. So there are zero chances of overlap. There are zero chances of any consumer getting confused that what is exactly the origin of a product. So as long as you are able to, through effective usage and through dissimilar trade circles, if you are able to prove this, that this trademark actually originates from you and people are not
Mm-hmm.
getting confused as to the origin, I
Mm-hmm.
believe you're all set, because the registry and the legal landscape would recognize this, that okay, when these two marks are being compared as a whole, of course,
Yeah.
there is significant dissimilarities. The consumer base for this product is different, the consumer base for the other product is different. So there are a lot of parameters that go on in this, which would take me about half an hour to explain. So I
Mm-hmm.
think this is the shortest explanation that I could afford here.
And I think that was really awesome the way you answered. And, coming from a non-legal background myself as well, even I have a question. So when we talk about a color, let's say a Tiffany blue, and we say that, it's been trademarked to them only. So let's say that Lay's comes out with a packet of chips and, they choose to take that blue. So can they? Because, the businesses are very starkly different. So is that a blue that nobody can use at all?
Very subjective here, because what happens is it completely depends upon the brand that we are dealing with. Now, you highlighted
Okay.
Tiffany. Tiffany
Yeah.
actually enters into a lot of brand collaborations with different entities. It recently
Yes, yes, yes.
collaborated with Nike and they even launched shoes. So it has
Yeah.
gone beyond the scope of services that it provides. And it is a
Mm-hmm.
well-known trademark as well. So well-known trademarks are provided a very wide ambit of protection, right?
Mm-hmm.
However, when you talk about chips and basically Lays, here the
Yeah.
chances of collaboration somewhat diminished, considering the kind of target audience that Tiffany has. Right. So
Yes.
Tiffany wants to appeal to a very different set of consumers, and Lays may not want to do that. Lays
Mm-hmm.
appeals to a general class of consumers, and it is accessible, it is purchasable by each and everyone to the extent possible. Right. So
Okay.
here it is actually very subjective, and it may cause some sort of confusion. Of course, people may look at it and relate,
Mm.
but the chances of collaboration between these two brands is fairly diminished owing to the target audience that
Yeah.
Tiffany looks at. So it is majorly, I should say, dependent upon the kind of business practices that a well-known brand observes.
Perfect. Thank you. I think that was very insightful. And I'll just take a last question. Okay, I'll take this one up. So this is Anshul Mittal, and he's saying, what is the connection between trademark protection and the assessment of a company's or brand's value?
See, if you are able to protect your brand, then you are able to create much more revenue for yourself. Because once I am protecting my brand and I am being authentic in the market,
Yeah.
other people will buy off products from me quite easily. Because वहाँ
Mhm.
पे तो the question of trust is no longer existent. They would obviously trust you because you have created that kind of authenticity in the market. So now your brand is actually generating a lot more income than it would have had it not protected its trademark. So here, we talk about valuation, the valuation would increase because you are actually getting a lot of income based upon your reputation here. So there is a very crucial interlink between the valuation, between the repute that you would want to maintain and the valuation of your brand.
Perfect. Thank you. I think that's almost up for the time. And in case anyone's left with any queries at all, we have a number flashing right on your screen. That is 9311 You can reach out to all of us here and, we'll be happy to take up your queries. And I would personally want to thank Ms. Ishita for taking out your valuable time and being here with us and sharing your insights. Any last words from you?
I think that should be it. It was amazing. And the questions directed were actually very insightful for me as well.
Perfect, perfect. Thank you, Ms. Ishita. Thank you, everyone, for joining in. We'll see you soon again with our third webinar. We'll be sharing the details with you. Please stay tuned. Thank you.
Thank you. Bye.